One of the things that separates America from a dictatorship is the Fourth Amendment. Because in a dictatorship, the police agents are basically able to search anybody's home whenever they want to. Whenever they think that there's any suspicion at all, whenever they think it's a good idea, those homes are vulnerable to police searches.
The Fourth Amendment to the United States Constitution provides that government may not conduct a search or seizure of an individual. That means may not interfere with your privacy unless there is probable cause to believe that that particular individual has committed a crime or will commit a crime.
Hey, open the door, please.
This was a very important guarantee in light of the history of mass searches that were conducted by British officials, where they would just, go into places of business and homes and just conduct these dragnet searches for evidence of a crime. Our framers wisely decided that before government could interfere with your freedom of movement or your privacy, it had to have a particularized justification for doing so.
They divided the power between two separate branches of our government because they did not want the police to have the power all in one branch, for the police to decide among themselves when they thought it would be a good idea to raid a home or a business. By separating the power between two separate branches of our government, the founders thought that they were giving the police enough power to investigate crimes and apprehend criminals, but not so much power that it would lead to government harassment of innocent citizens.
Stand right there.
As a result of an arrest warrant and previous buys that were made here, we've now served a warrant and seize this apartment.
What the Fourth Amendment requires is that a search may not be undertaken unless there is probable cause. And probable cause in that context means a good reason to undertake the search. Now, it doesn't necessarily mean that it is more likely than not that evidence of a crime would be found in the search, but it does mean that a fair-minded person in the position of the police officer would have to have a good reason for thinking that there would be that kind of evidence.
With respect to arrests, we're talking about the power of government to deprive someone of their liberty, to take someone away from their family, to put handcuffs on them, and to put them in jail.
We got a warrant for the house, man. They said that warrant for the house.
With respect to search warrants, we're talking about the power to break down the front door of somebody's home and to potentially hold the people in the home at gunpoint while the police officers turn the place upside down looking for evidence of a crime. We don't want those powers unleashed on the basis of rumor, gossip, or simply the hunch of the local sheriff. And that's why the founders established probable cause. They established a higher threshold before the police are able to exercise those powers.
Although the police are bound by the Fourth Amendment, occasionally they do not follow the law and conduct searches without probable cause or search warrants. To help deter this, courts refuse to allow prosecutors to use such illegally seized evidence in court. It's called the Exclusionary Rule because any evidence seized in such an improper manner is excluded by the court.
We've had instances in this country where the exclusionary rule has not been in place. In the city of Cincinnati, for example, in 1959, the exclusionary rule was not in place, and the police only applied for a single search warrant during the entire year. So we know that when the exclusionary rule is not in place, the police do not bother applying for search warrant applications.
I think we've been mobilized as an effective.
The downside of the exclusionary rule is that it's costly, but also inefficient. It's costly because it prevents the public and juries from knowing the whole truth. And of course, that is a very important cost that our system pays. The primary purpose of a criminal trial or of any trial is to bring out the truth. And when the system cannot do that, that is a significant disadvantage It's also inefficient. The exclusionary rule is inefficient because it does not punish primarily the officer who did not comply with the Fourth Amendment. So perhaps a better way would be to impose a fine on the officer, but still allow the jury to see the evidence.
There will often be disagreement over what makes a search unreasonable, over how to deter some overzealous police without undermining the ability of all police to fight crime. That's understandable. At the heart of the Fourth Amendment and many other protections of the Bill of Rights lies one fundamental question: how best to balance society's need to maintain order against your right, my right, the right of all citizens to personal liberty. I'm Tim O'Brien.